You're parked on the shoulder, or maybe you're standing on your front porch, or you're waiting in line at a transit hub. The window rolls down, or the doorbell rings, or an officer steps into your space with a calm, practiced tone. They don't draw a weapon, they don't raise their voice, they just ask a question, something polite, something simple. Do you mind if I take a quick look in your trunk? Mind if I check your bag? Any objections to me walking through the property? And in that half-second, something heavy happens in your head. You've been raised to be respectful. You've been taught that refusing an officer looks suspicious. You want to show you have nothing to hide. So you nod, you smile, and you say, "Sure, go ahead." What you just did isn't cooperation. In the eyes of American law, it is a voluntary surrender of a constitutional boundary. Here's the core legal paradox that trips up millions of citizens every single year. The system is supposed to protect you from unreasonable searches. The Fourth Amendment exists precisely so you never have to prove your innocence. Yet the most common way lawful searches bypass judges, warrants, and judicial oversight is through a simple verbal waiver. The moment you say yes to a consent request, you don't just open a door or a trunk. You hand the state a legal free pass. You convert what should require probable cause into something that requires nothing but your permission. And before you think this only applies to guilty people, understand this clearly. Innocence is not a legal defense against a search. Evidence doesn't care if you're innocent. If an officer finds something ambiguous, a prescription bottle without a label, a modified exhaust, a bag of legal powder that looks questionable, a text message taken out of context, the moment it's discovered during a consented search, it becomes admissible in court. The search is legal because you agreed. The evidence sticks because you said yes. This isn't about fear-mongering. This isn't about assuming every officer has bad intentions. Most officers are simply doing their job within a legal framework that incentivizes consent because it's faster, cleaner, and legally bulletproof. But you don't have to navigate this framework blind. The tension you feel in that moment, the social pressure, the fear of looking uncooperative, the instinct to comply is real. But the law doesn't require compliance to prove your rights. It requires you to hold your boundary. Welcome to TED Law. Today, we're breaking down exactly how consent works, what you're actually giving up when you agree, and the precise de-escalating language you can use to protect yourself without turning a routine encounter into a confrontation. To understand why consent matters so much, we have to strip away the television drama and look at how the Fourth Amendment actually functions on the ground. The framework rests on three interconnected legal doctrines. If you understand these three, you will never again view a consent request as just polite conversation. You will see it for what it is, a constitutional transaction. First, the reasonable expectation of privacy. Established in the landmark case Katz v. United States, 1967, the Supreme Court ruled that the Fourth Amendment protects people, not places. The test is simple. Do you have an expectation of privacy that society recognizes as reasonable? Inside your car, your bag, your home, your pockets? The answer is yes. Think of this expectation as an invisible fence around your life. The government cannot cross that fence without a warrant issued by a neutral judge, an established exception like exigent circumstances, or your explicit permission. The fence isn't there to hide crimes. It's there to establish a baseline of personal sovereignty. Without it, you're just living on public property. Second, the consent search doctrine. This is where most people get tripped up. In Schneckloth v. Bustamante, 1973, the Supreme Court held that a consent search is valid as long as it's voluntary, not coerced, not forced by threat. Voluntariness is judged by the totality of circumstances. Notice what's missing. Officers are not legally required to tell you that you can say no. In Ohio versus Robinette, 1996, the court explicitly ruled that police do not have to inform you of your right to refuse consent. That's right, you can legally waive your constitutional rights without ever being told you have them. Courts have consistently held that as long as the environment isn't overtly coercive, a simple yes is treated as knowing, voluntary, and intelligent. This creates a massive gap between legal reality and public perception. Media shows detectives kicking doors. Reality shows officers using calibrated, polite language that triggers social compliance. The law doesn't require them to read you your rights before a search. It requires you to know the fence exists and to keep the gate locked. Third, the exclusionary rule and the fruit of the poisonous tree. Born from Weeks versus United States, 1914, and applied to the states in Mapp versus Ohio, 1961, this rule states that evidence obtained through an unconstitutional search cannot be used against you in court. This is the real reason consent searches are so aggressively used. Prosecutors and officers know that if they skip the warrant and rely on your permission, the exclusionary rule never gets triggered. The evidence is clean. The suppression hearing never happens. You essentially hand them the legal shield they need to bypass the most critical checkpoint in criminal procedure. Consent is the legal equivalent of handing them the master key. Once they turn it, they don't have to explain why they entered. They just have to say you invited them in. Understand this. The legal system doesn't function on fairness in the moment. It functions on technical waivers, and consent is the most common, most legally pristine waiver in American jurisprudence. Now, let's talk about the weight of this, because legal theory means nothing if we don't address the human reality of what happens when you're standing in that driveway, on that roadside, in that lobby. The cost of a careless yes, the cost of trading constitutional clarity for social compliance, the cost of assuming that refusing an officer makes you look guilty, when legally it only makes you look informed, the cost of believing that cooperation equals safety, when the law rewards precision, not politeness. Every time you consent unnecessarily, you chip away at the practical enforcement of the Fourth Amendment, not just for yourself, but for the civic standard. Rights aren't like bank accounts. You can't save them up for later. They're like muscles. They atrophy when unused. They strengthen when exercised with calm, deliberate clarity. The fear driving compliance is real. You fear escalation. You fear the power imbalance. You fear that saying no will turn a 2-minute stop into a 3-hour ordeal. But here's the uncomfortable truth the courts have repeatedly affirmed. Exercising a constitutional right is not probable cause. Refusing consent does not legally justify extended detention. It does not justify arrest. It does not justify retaliation. The moment you tie your rights to the comfort of the officer, you hand over the very thing the framers fought to secure. James Madison and the authors of the Bill of Rights didn't draft the Fourth Amendment for people who had nothing to worry about. They drafted it for the vulnerable. They drafted it for the ordinary citizen facing the machinery of the state. As Justice Sotomayor has repeatedly emphasized in her dissents and opinions on policing, the dignity of the Fourth Amendment lies in its requirement that the state justify its intrusion before it happens, not after it has already rummaged through your life. When we outsource that justification to a casual yes, we don't just waive a rule, we waive a centuries-old boundary against arbitrary power. You don't need to be a lawyer to navigate this. You just have to understand that the law doesn't demand you look cooperative. It demands you act lawfully. And the lawfulness of refusal is absolute, as long as it's delivered with calm precision. The invisible cost of untested assumptions is higher than you think, but the visible power of informed navigation is exactly what separates a passive citizen from an empowered one. This isn't just a roadside theory. Consent searches show up in every layer of modern life. Let's map out exactly where you'll encounter this pressure, bust the most dangerous myths, and give you the exact language to de-escalate while holding your ground. Scenario 1. Traffic stops and vehicle searches. Legal myth. If I refuse a trunk search, the officer will arrest me or tow the car for looking suspicious. Actual right. Under Arizona versus Gant 2009, officers cannot search your vehicle incident to arrest unless you're unsecured and within reaching distance of the interior, or they reasonably believe evidence of the crime of arrest is inside. Beyond that, they need your consent or probable cause. Refusing consent does not create probable cause. What to say? Officer, I respect your time and your role, but I do not consent to any searches of my vehicle. I'm happy to provide